Good morning. I would say welcome to the Court of Appeals, but I think everyone in the courtroom is an employee here. So welcome to anyone who's watching online. We have one case on our calendar this morning, and it is 21 CV 762 Jefferson 11th Street LLC et al. Versus the District of Columbia. And counsel, when you're ready, if you could introduce yourself for the record and let us know how much time you would like for rebuttal.
Thank you. May it please this honorable court. My name is William Cornwell. First of all, I'd like to thank you for allowing me to appear remotely via Zoom. And secondly, I would like to reserve 3 minutes for rebuttal.
All right, whenever you're ready to start.
Justices, this case arises from a small family-owned limited liability company, a single-purpose limited liability company, which ran and operated a residential rental property here in the district. The company's Jefferson 11th Street LLC. As I said, it's a small family-run business, and it had no problems with this building other than just normal aging remediation kind of fix.
So counsel, I hate to cut you off, but we're familiar with the basic facts, and we've read, I believe, the 9 briefs in this case. So we'd like to just go ahead and jump into the legal arguments
Yes.
if we could. And
Thank you.
The first question is whether or not this appeal is properly before us, and if you could go ahead and address that and explain to us why you think it is.
Yes, the appeal is properly before you. And when it was initially filed, there remained an open receivership that has since been closed. You considered jurisdictional issues and ordered further briefing, as you may know from the 9 briefs you made reference to. I know there's a lot of paper. There is no question. There's nothing that remains for decision below. The issues, and there are 4 discrete issues, are the first one, this district has conceded essentially that this court's decision in 2022 in Sizer versus Lopez Velasquez 270.
Well, I'm sorry you're getting us to the merits, but I'm still wanted to pause on why this case is properly before us. And your argument seems to be, well, everything's final now, so we can go ahead and hear it. And I'm wondering if you could provide us a little bit more support for that proposition.
We argued in the briefs on jurisdiction that an appeal which may be premature, which is later cured by a final judgment, and there were final judgments entered in this case on all issues except for the open receivership when we filed the original notice of appeal. Thereafter, the appeal of the receivership issue became...
So, counsel, sorry to cut you off, but would you agree that in this court's order on the district's motion to dismiss, that the order dismissed the receivership claims from the appeal at that time?
Yeah, that appeared to be what the order said.
So regardless of subsequent finality with respect to any or all of the claims, wouldn't you agree that Jefferson, your client, would have had to have filed a new notice of appeal with respect to at least just the receivership claims?
No, Your Honor. And the reason I say no is the authority we cited, which said that an appeal prematurely filed that is subsequently mature is permissible. And that happened here.
But in West, there was no order dismissing the claims as premature. So that, I think that seems to be one big difference if West is the case that you're relying on.
But
right?
I didn't.
You have the Court of Appeals telling you these claims are not properly before us. They're premature. It seems that you would need to file a new notice of appeal, no?
No, and you said the operative words, it's premature. The court didn't say it's dismissed with prejudice. And that's why I keep referring back to the prematurity being cured.
Does this court ever say that anything is dismissed with prejudice? That's not really language that we use on appeal.
Well, I can't comment on what your prior opinions have said. I'm sorry, I'm not that familiar with whether you've ever used that language. there is no question that there are issues that arose as a result.
I guess I'm just wondering, what is your authority if you have an order from this court saying these claims aren't properly before us, they're premature, to say, oh, well, it's okay, we can wait out the clock and the case can become final and then we can proceed and sort of disregard the order that this court issued?
Well, the court did enter an order seeking supplemental briefing on issues 3 and 4, which are the issues.
Certainly we saw supplemental briefing, but that wasn't a decision. That was just, we'd like more information from you.
Right. And well, it certainly suggested that the court had not fully and finally resolved those issues. As you're suggesting, dismissal of that appeal would have done. I'm not arguing with you. I'm just trying to answer your question the best I can.
Right. I'm just asking if you have any other authority besides West to say that we could consider these claims, notwithstanding our order saying that they were not properly before us.
Not with me here today, no.
Okay, counsel, so that's the TRA claims, and I'm just trying to narrow down what we should talk about today. So your client has never actually challenged the CPPA injunction, right? And am I correct that you're still not doing that?
Correct.
So we'll put aside the TRA claims for a moment. So really, we're talking about the CPPA monetary damages claim, right?
That would be the other issue that remains, along with, well, if you carve out all the TRA related claims, yes.
Right.
Yes.
And then am I right that you are at this point arguing, and I'm not saying maybe you're arguing in the alternative, but you're relying on West and potentially Rule 4A2. Are you no longer relying on the injunction provision in 721 A2A?
I'm not sure I understand your question, but
I'm sorry. So
on the CPPA claim, we're relying on the final judgment entered by the court.
Okay.
And the notice of appeal that was filed subsequent thereto.
I'm not sure the notice of appeal was, or it's being treated as filed subsequent thereto. Is that what you're saying? Under Rule 4A2, it was filed before the trial court order became final, right? I mean, that's why we're here.
That I'm frankly not real clear about. I'm sorry.
So the court ruled on the CPPA monetary claims in 2021, but the case didn't become final until 2023.
Correct.
Okay.
Notice of
And
appeal.
you're saying that the 2021 order is now final by virtue of the 2023 order. Is that
Yes.
your understanding?
Yes.
And that proposition, you're relying on West.
Yes.
Okay.
But you have an additional fact on your side, which is we have already issued an order, this court has, saying that those CPPA claims survive. That we rejected the district's motion to dismiss those as being untimely filed. So, what litigant, at least as the CPPA claims, we can put aside the TRA claims for a minute. What litigant would file a second notice of appeal after a final judgment in 2023 when you've already been told by the Court of Appeals your CPPA claims remain alive? I assume that's part of, that yes. Plus West really gets you all the way home.
Yes, that's what I thought I said earlier. I apologize if I was unclear. That is exactly what we've argued, and I agree.
Yeah, I suppose the earlier conversation about the TRA claims, though, it doesn't really work because kind of the opposite was true. You had been told these TRA claims are out of the appeal after the district filed a motion to dismiss. A motions panel said, yeah, you can proceed only on the CPPA claims, not on the TRA claims. So while I feel like it would be odd to hold it against you that you didn't file a notice of appeal again on the CPPA claims that you were already told by this court are alive and well, I find it also somewhat odd that you didn't file a notice of appeal for the TRA claims that you had been told those things are out of the case. So West doesn't really answer either of those questions because West didn't involve sort of interim order from this court saying what is and isn't alive. And if it had, I assume it would say, well, the things that had been killed before they got to a merits panel remain dead and they don't get revived. And that would be kind of a weird rule if parties if appellees couldn't even file a motion to dismiss and get a case dismissed as being prematurely filed, as the district tried to do here, you would think they would be able to do that. Sorry, there might not have been a question in there. just me
hear you.
ruminating.
Agree or disagree? Yes.
I hear you loud and clear and understand the quagmire that's created for the court, and I apologize for it. Should I go ahead and proceed with the argument?
Well, sorry, I have one other question on that. So Judge Deal said that the order from the motions panel on the district's motion to dismiss led your client to believe that the injunction or the CPPA claim was still alive. But the order said the CPPA claims as to which an injunction has been issued. And does the fact that your client is not appealing the injunction itself, which I think you just confirmed a few minutes ago, what role does that play in this court's jurisdiction? I mean, it seems now like you're talking about, again, 721A2A. But if you're not actually challenging the injunction, then do we have a jurisdiction under that provision?
I would say you have jurisdiction on the final order entering the money judgment under the CPPA that we're appealing, on which a notice of appeal was issued timely. I'm not sure what else I can tell you. The record seems pretty clear on that, and we, as Judge Deal just mentioned, we relied on the court's order saying this appeal was viable to go forward.
Just
So, on the CPPA,
clarify the timing for me. You file the notice of appeal and then the district files its motion to dismiss before you file your opening brief. Is that correct?
I think that's true.
Right. So at that point, this court didn't know what your claims were going to be on appeal.
I don't think that's quite right.
No.
Am I mistaken about the timing?
The opening brief was August 4th, 2022. The motion to dismiss was August 24th, about 3 weeks later.
Okay.
I stand corrected. Thank you. So should I proceed with the CPPA argument?
I'd be interested in hearing that.
Yeah, I think the district concedes that the court's order entering a judgment for $425,000 in penalties and civil fines can't stand because it was entered based on a statute that didn't provide for such until after December when the 2018 when the statute was amended. And so any damages that the court awarded in the form of fines and civil remedies and back rent for the period before that can't be the subject of a judgment. And they've conceded it needs to be remanded for reconsideration of that.
I think that's right. So do you agree with that too? That 2016 is the operative date for that calculation on remand?
Yes, I think
so. You agree that the Attorney General had that authority as of the amendment in 2016?
Yes. Initially, I know we took a different position, but I think we've been convinced that that was more correct is from December of 16. Backwards can't be the subject of an award of these back rent and civil fines. And if I may argue briefly about the other issue in the case or other issues, there's simply no record evidence to support piercing the veil to Mr. Parker as the court entered. And the suggestion that he was an officer, manager, or agent of the company is just wrong. This was a manager-managed LLC. The record and the evidence is clear that SCF management managed the property, was never deprived of funds to repair any of the problems found on site. At best, what there is a negligence claim against the manager. There's no evidence of commingling of funds because there were no funds.
Isn't part of the problem here, though, that the district put forward a statement of undisputed facts and you didn't contest them?
That is untrue. The record reflects
Well, I understand your argument is no, we said things in our briefing that contested their facts, but there's there's a procedure, right?
Yeah.
The rules of civil procedure say how this is supposed to work. And one party puts forward their statement of undisputed facts, and then the burden shifts to the other party to identify in a precise format the facts that are disputed. And my understanding is that you failed to do that, and in fact, filed a few things, and maybe one was struck, right, by the court because you didn't follow the rules or the court's instructions.
There was a supplemental submission by the trial counsel in March before the order was entered, which the court ignored and made no reference to striking it that I'm aware of, and simply apparently failed to understand that it had been submitted or that it impacted and created issues of fact at a minimum. But even with that said, the district was required and had the burden to prove a basis to pierce the veil, and just utterly and completely failed. What's cited in support of piercing are things like that there's a failure to observe limited liability, a failure to observe corporate formalities, which the statute, it's a legal matter in the district, says the failure of a limited liability company to observe any particular formalities relating to the exercise of its authorities and powers shall not be a ground for piercing the veil. In the realm of LLCs, that factor is inappropriate because informality of organization and operation is both common and desired. So there was no evidence to support the fact that there was intermingling or somehow personal use of funds, because there were no funds generated.
So counsel, on the piercing question, I mean, don't we have a more fundamental point, which is that Mr. Parker never actually paid the amounts that he was ordered to pay, and hasn't, and he cannot now be ordered to do so because the receivership has been wound down?
Well, the company, along with the members, did pay what was ordered through the piercing order, and so Mr. Parker contributed his pro rata share.
Okay, I might be misunderstanding something, but
yeah, there's no question that the funds that the company and Mr. Parker were held jointly and severally liable to pay were paid.
So if the company paid its share, I mean, what does that have to do with piercing the veil, right?
Well, I agree with you. It doesn't, but it certainly doesn't leave appropriately an order without any evidence to support it that Mr. Parker was subject to having personal liability. That's our point.
right. But what would be the relief now? I mean,
that he would be found not to have engaged in behavior that led to piercing the veil to him personally being liable. You're right, we can't take the money back that was paid in, but we can certainly put aside what is an erroneous order finding that there was any basis for piercing the veil in the first place.
So you're sort of looking for a reputational correction? Am I understanding correctly?
I think it's more important than reputational, but yes, that is, it's a clearly erroneous finding without any support in the record, and the district bore the burden on this point. It should have been.
I'm sorry, what's your
summary judgment?
Excuse me, what's your support for our authority to issue some sort of correction of that sort that doesn't have any practical impact on your client? I mean, beyond reputation.
Well, in the aftermath of the case being essentially ended by settlement and or bankruptcy and ending the receivership, I don't have anything to cite you to under these sort of strange and unusual circumstances. It was coercive is the point, and it is reputational. And I think this court has the ability to correct an error where it finds one. We're not asking for the money to be paid back, if that's the question.
So your time is up. Do you have any other arguments you would like to make?
Well, I was going to argue that there was clear error committed in allowing the 800,000 plus in tenant rents and differentials, moving expenses were not authorized by law until an amendment to the TRA in 2021. And I think you're aware of what we're talking about there. And that's the other argument I would have addressed had I had time.
All right. I mean, you're welcome to take a minute or two to address them if you would like to, but otherwise I'll ask the district to take to the podium.
Yeah, what happened here is the owners of the company had sought repeatedly to engage in a hardship or to file and did file and had approval for a hardship petition for this 100-year-old building to renovate it, then sought to and proposed to the trial court a plan to abate the violations, which the court inexplicably refused to allow, and turned the property over to the receiver, who $2 million plus later had a shell of a building, no tenants, and had run up over $1 million in rent differentials for the tenants. I don't think that's what the receivership statute was ever intended for. The city or the district basically weaponized the receivership statute along with the CPPA to cause everybody to lose in this instance. There's no evidence in this record to support, and the statute particularly requires that the court find that the respondent has not provided the court with a sufficient plan for abatement of the conditions. And the court just sort of overlooked that and moved on and appointed the receiver, and it led to all of these untoward outcomes, which are the subject of continuing litigation in the federal district court. And these orders were the subject of a motion for immediate review by the federal district court attorney, who unfortunately has passed away, Jim Marquitos, that the court denied a certificate for immediate review in November of 2018, when the receiver still held the bulk of the $2 million and had not expended the funds on, as I said, on tenant rent differential, moving expenses, and other expenses that were not authorized by the statute until an amendment in 2021.
All right. Thank you, counsel. We'll hear from the district
Thank
now.
you.
Morning, may it please the court. Sonia Lebsack for the District of Columbia. Let me jump right in on appellate jurisdiction because I think that my friend's argument has simplified those issues substantially. I understand my friend to have abandoned that there was any jurisdiction prior to the 2023 entry of final judgment. And so I'll cut right to that point and what that 2023 final judgment could rescue from the conceitedly premature notice of appeal that was filed in 2021. And what I didn't hear any arguments about was that the TRA orders have any appellate jurisdiction in this court. And I think that's correct. There is no appellate jurisdiction over any of the TRA orders based on this 2023 final judgment.
I didn't understand opposing counsel to be conceding the point. I understood opposing counsel to be saying, well, that's the work that West does. West says, if you prematurely file a notice of appeal, and then prior to submission to a panel, the appeal ripens, their position is, well, West says that that appeal is fine. There's jurisdiction to hear it. And West does indeed seem to say something like that if you just read it by its terms. I'm not sure we should read it so sweepingly, but that's their argument.
Yes, I don't think that would save any of the TRA orders. My understanding of West is that it's part of maybe sort of a common law doctrine of cumulative finality. And West was actually the only decision that I found where this court sort of seemed to use it. But I'm not aware that this court has, number one, adopted that common law doctrine. I mean, there is West, that is authority, but what the scope of that doctrine is. And I don't think it would rescue the TRA orders, which again, were years out of time, interlocutory orders in 2021.
But
What
so
it might say,
if you put aside that we dismissed the TRA claims for a moment, isn't it true that, or even if you proceed on the notion that we dismiss the TRA claims, if Jefferson had filed a new notice of appeal from the receivership orders, or had timely filed in the first place, a notice of appeal from the receivership orders, wouldn't the district have said that those are moot once the receivership was ended? I mean, so the notice of appeal could have only been filed after the receivership ended, right? Otherwise, they
Correct.
would have been premature or interlocutory. And once the receivership ended, the district surely would have come in here and said they're now moot.
That's right. And that's an independent and sufficient ground why there's no subject matter jurisdiction.
Okay,
You know,
but then when would a party ever have the opportunity to appeal specific receivership decisions, not simply the appointment of a receiver or the termination of a receivership, but individual receivership decisions that could cause harm to the party?
Right. I do think there's a number of mechanisms that are available in a receivership proceeding, just as in any other civil litigation, to aerate issues up to the courts. For example, there's a practice in the federal courts of appeals using Rule 54B to sort of allow sort of parties and different claims to jettison out of receivership proceedings and get reviewed by the appellate courts. There's a number of sort of other doctrines, collateral order doctrine. I guess if something really went off the rails, there'd potentially be a mandamus action. There could be a sort of an amicable contempt type of agreement where the parties agree that an important issue needs to be heard. And so that the contempt could also, arise in appeal. Obviously, if there's any injunction, potentially that would also arise. And so there's a number of very well-established ways to get problematic orders or perceived problematic orders up to the Court of Appeals on time. And it's notable here that Jefferson 11th Street and, all of the appellants didn't use them at every turn. They did not attempt to use any of these tools. And in part, we can see from this record that they didn't use them because they actually agreed. These are consent orders to appoint the receiver. They're consent for scenario 2. But so that's sort of how I think, the court should not be troubled by the mootness here. This is not a case where there were not many opportunities to do something if something was amiss. Going back to the appellate jurisdiction, the one thing I would say is that, it's also not clear to me that West survives Rule 4A2. A number of federal courts of appeals have said that Rule 4A2 supersedes sort of the common law doctrine. And this seems to make good sense. And this is discussed in Outlaw. Judge Roberts talks a little bit about how Rule 4A2 essentially supersedes sort of this broader, sort of messier common law doctrine and requires folks to use Rule 4A2. And Rule 4A2 under first tier is narrower.
But there's an important distinction between the federal system and ours, which is that the timeliness question under 4A2 is largely coextensive with the jurisdictional question of finality in the federal system, because federal civil appeals, the timeliness is jurisdictional vis-a-vis 28 USC 2107, and we don't have an analog for that. So timeliness under 4A2 is timeliness. West seems to speak to finality / jurisdiction. So what's your position, that we don't have jurisdiction, or just that the notice of appeal was premature and therefore untimely?
Right. Compliance with Rule 4 is not jurisdictional. This court has said so. It is a mandatory claim processing rule. It is mandatory. And I think it's one of the important bright lines to keep appellate practice administrable. And so for sure, it could be that Rule 4A2 can operate alongside the common law doctrine, and this court could certainly say so. But I'm not, again, I guess I feel, having sort of tried to understand what is the scope of that doctrine, I don't know how far it extends. And that would be useful to understand, because, for example, I don't think even the common law doctrine expands to sort of a kitchen sink type appeal. And if it did, I think, there would be questions about why should that be the rule as opposed to either Rule 4A2, which courts have interpreted both narrowly and broadly. The district would urge a narrow interpretation that's closer to the heartland of what we understand Rule 4A2 to be doing, which is a sort of housekeeping function when an appellant sort of jumps the gun a little bit and sort of there's a ministerial problem with what would otherwise be itself a final judgment, as opposed to what happened here. There certainly wasn't a final judgment a final judgment in 2021, but it was potentially maybe certifiable under Rule 54B. And because that's true, so there is federal authority for the idea that that order can then relate forward. And we certainly acknowledge that authority, but we think the better rule would be to read it more narrowly so that it just applies in the circumstance in which we think it was intended. And so, it's in terms of whether there's any jurisdiction over the CPPA order, it would come from, in our view, at most, a broader reading of Rule 4A2.
And so
Then
just
we
so I'm
would say-
clear, you're saying that the CPPA order could potentially have been certifiable, not the TRA orders.
Correct. There's certainly with a CPPA order, there's no dispute that that order was conceptually appealable under Rule 54B. And if Jefferson 11th Street wanted to immediately appeal that order, they could have filed a Rule 54B motion. And maybe the court would have granted it, and maybe they would have come on appeal on that CPPA order. They didn't do any of those things. What they did is they filed a premature notice of appeal and did nothing else. And
I mean, the majority of federal circuits seem to go with the broader interpretation, and I think there's only two that go with the narrower interpretation. So, I mean, you're recommending that we side with the minority on this?
yes, and I think because it's a better rule. I think it's a better rule for courts. I think it's a better rule for parties. This case would be my first example of how this isn't a great way to have sort of a rule where folks can just bring appeals that have candidly no jurisdiction, have them sit in sit in the appellate court for years without any jurisdiction while the parties sort out briefing, the court tries to figure out which way is up. And then the hope is that the Superior Court beats the appellate court to the buzzer. And then suddenly there's all this appellate jurisdiction that wasn't there before. It just doesn't seem like a better rule. So we would say.
But aren't appellees in a pretty good position to protect against that sort of malfeasance that you're positing? Because, they can do what you guys did in this case. You file a motion to dismiss very early on, and you can get claims kicked out on that basis. What's wrong with that?
Sure. And we certainly did that here. Again, I think this case is a great example of sort of how well that works. And it doesn't work so well.
It's certainly complicated in this case because of the variety of claims, maybe partially because the order that we issued on the motion to dismiss isn't crystal clear on what we were doing. But I understand it to be saying, more or less, the TRA claims are out, the CPPA claims are in. And you might tell me that's the wrong way of understanding it, but that's how I read it. And if that's the right way to read it, haven't we already settled that the CPPA claims are in? I hear you making an argument that they should be out too. But to me, it just seems like sort of law of the case here. We've decided that we're going to hear the CPPA claims. A prior panel of this court decided that. I wasn't on it. I might have reached a different judgment, but that's the judgment they reached. So why would the district get a second bite at the apple on that?
Sure. Well, I think it does appear to be a sort of a common practice that motions panel, like the merits panel, sort of has final say on what's in front of the court, and that seems to be a common practice. So perhaps there's, coming all the way into the merits, there might still be sort of an open door to reconsider. But here, of course, we do have this final judgment, and it's sort of a game changer.
Can I just pause there? That's definitely true. So, I mean, oftentimes our orders will say, we defer to this jurisdiction jurisdictional question to the merits panel. That didn't happen here. So, but even still, we definitely have some cases that say a merits panel can sort of override the judgment of a motions panel. I think there probably needs to be pretty good reason to do that. And here, I wonder if you can address the practical concern of what I think is a pretty good reason not to do that, which is sort of a lulling concern. Jefferson really had no reason to appeal the CPPA claims after the 2023 entry of a final judgment, because we had already told them the CPPA claims are alive. That to me starts feeling like a really sort of gross injustice we'd be visiting upon Jefferson to pull the rug out from under them. They could have quite reasonably relied on our order saying the CPPA claims are still going, not filed a notice of appeal based on that. And then for us to say, you know, JK, they're dead too. It doesn't strike me as being the fairest thing.
Sure. I think in the sort of details of this case, I think that is a fair point.
Okay, good enough.
But so, I mean, jumping ahead to the merits though, because it kind of ties into this question. I mean, is your colleague right that everyone is on the same page now with respect to remand for recalculation as of 2016?
That's right. My best understanding of appellant's reply brief and confirmed by my friend today is that the parties are in complete accord that with respect to the monetary relief ordered by the CPPA order, it does need to be remanded to the Superior Court for a recalculation in light of this court's decision in Sizer, which dates the Attorney General's authority to seek monetary relief to December 2016.
And
so we're foursquare in step on that.
And so, but if you think that if you're asking us to dismiss the appeal instead, then Jefferson doesn't even get that relief, which you otherwise agree is justified, right?
Actually, you know, that's, you know, we have a note in our brief, and I believe this is absolutely correct under current precedent, that there remains an opportunity for Jefferson 11th Street to go back to the Superior Court and ask for under 60A1. It's essentially mistake of law. The Supreme Court's decision in Kemp, I think a couple of years ago, said that an intervening decision like the one this court issued in Sizer arises a mistake of law, and a party can go to the Superior Court and basically ask for relief from the judgment. And the district put in its papers that it would not oppose that maneuver, and it wouldn't raise it has to be within a reasonable time. And we said we would waive that as long as it's within 1 year of the final judgment. And that's still where we are. So for sure, standing right here and right now, they can go get relief in the Superior Court on that. They haven't done that yet.
Sorry, just to clarify, 1 year from the 2023 judgment, which is, I can't remember what.
It's in June.
Sorry,
June.
in June. So they have until next month.
Yes. I mean, that's by virtue of the federal rules. That's just simply the way amending judgments works under the federal rules. So what the district has said is that, you know, we won't raise any special objection to sort of having that they waited a whole year to do. I mean, they waited a long time after Sizer to, you know, go back to the Superior Court and say, oh, we have a problem here. But the district has agreed that, you know, if they take us up on this, they
and
can go back and raise
hypothetically
it.
speaking, if we hadn't decided this case by next month, they should still, your view is they should still do that, even though we obviously have jurisdiction over the case.
Oh, no, quite right. Certainly, we would hope that court, an orderly administration would be that the court would issue its decision. There would still be time, and they could move in the Superior Court. I know there's also a procedure whereby they can move in the Superior Court, and then there can be
June is
creation.
next week. So just to clarify the calendar. I don't
Right.
remember what
Yeah.
day in June of 2023 the Superior Court order came out, whether we're talking about the end of June or the beginning of June, but
Right.
I'm just really focused on the logistics here.
Yes, and I think any, you know, the objection the district has agreed to waive is the reasonable time, which is what we're responsible for under the federal rules. Otherwise, the federal rule requires a motion under A1 to be brought within a year.
But I mean, nothing would, I mean, even if we still had jurisdiction over the case, Jefferson could file the motion. The trial court query whether the trial court could act on it. But nothing would stop Jefferson from filing the motion before the appeal is decided, right?
That sounds right to me.
Let me ask you another question, though. If, I mean, whether you term it jurisdictional or mandatory, you're in the district's invocation of the mandatory claim processing rule, is it your position that we cannot reach the merits in this case?
As to the CPPA
Right.
order, that would depend on the scope of Rule 4A2, I think, and we would urge the court to read it narrowly, and so it would not fall within the exception. And so, yes, we would say we've invoked, you know, in a prompt fashion, our right to dismiss their notice of appeal. And I think that's, you know, again, and they did file their opening brief, to be sure. But within, I think it was 10 days, we had filed a motion to dismiss, pointing out that there was no apparent colorable basis for jurisdiction. And of course, standing here today, the parties have come to an accord that there was in fact no jurisdiction at that time for that order. I'm happy to address any of the other questions the court has, but I think that with the appellate jurisdiction issues and the discussion about the CPPA remand, I don't have anything further.
All right, thank you very much.
Thank you.
Mr. Cornwell, we'll give you just a few minutes for rebuttal, but you need to take yourself off mute.
Thank you, Your Honor.
Thank you.
I was asked what support is there other than the West case. The actual language of the rule itself, appeal of right as of right when taken, A, appeal in a civil case, 2, filing before entry of judgment, a notice of appeal filed after the court announces a decision or order, but before the entry of judgment or order is treated as filed on the date of and after the entry. That language in and of itself, along with this tortured procedural history, I think did lull us into a belief that the court had accepted jurisdiction, perhaps wrongly. I'm not being critical of the court or of the district, my friend at the district. But I wanted to make sure I made that comment on the record. Really, that's all, unless the court has questions that I really had to say in rebuttal.
This is not a question so much, Mr. Cornwell, but a comment on what opposing counsel had suggested, which is, I think the mechanism. If you wanted to take them up on the offer, you know, I don't know if you should leave here today feeling especially great about the likelihood that, you know, which of your claims we might or might not address. And it does seem that you have until June 16th. I think that's when the trial court issued a final order to get under the 1-year mark under Rule 60. And while I believe the trial court cannot rule on that while the appeal is pending before us, you can always ask for an indicative order. You know, there's a process that we sometimes have where a trial court says, if the Court of Appeals remands it to me for this purpose, then I'll go ahead and rule this way. And, you know, that might be a process you might want to consider. So I don't know if that's been a conscious choice not to take them up on it. You know, I don't mean to steer your litigation. But I think that is a potential avenue that's open to you, independent of some of these dicier questions of which claims have been timely appealed.
The June 16 date you just mentioned is seared and etched in my brain. Thank you. I will take up your comment with my client immediately upon conclusion of this hearing. And I thank you.
Well, thank you very much, counsel. We appreciate your argument today, and the case will be submitted.
All rise.